which coincidentally is the same date that the letters for the respective commissioners were also issued. And I would ask the Secretariat to provide the witness with the MOJ 3 series, that is MOJ 3A, B, C, and D. Are the documents before you, Mr. Tambedou?
Yes, they are.
Should I allow you a second to go through them, or you're fine? Great. Let's begin with MOJ 3D. Which was the appointment of the chair. The current doyen of the bar. It's dated the 12th of July 2017, and it is signed by the Solicitor General at the time. Great. So it is clear that the commissioners were headhunted, which, as you have explained, was a mechanism put in place by yourself to ensure that you got what the Ministry of Justice, acting on behalf of the government, wanted in a commission and in a chairperson. A letter was issued to him, and the letter is marked MOJ 3D. Now, this part would have to be tedious because I wish for us to go through each of these letters and read them. If you could do me the honors of reading the letter. Perhaps if you could just highlight the date, the addressee, who it's coming from, the heading, and then the content.
The letter marked MOJ 3 is dated 12th of July 2017. It's addressed to Suahata B.S. Jane, and it's headed Appointment as Commissioner in Commission of Inquiry. It is signed by the Solicitor General and Legal Secretary, and the letter reads, I am pleased to inform you that the President of the Republic of the Gambia, His Excellency Abubacarr, acting under Section 200, subsection 1 of the 1997 Constitution of the Gambia, has appointed you as a commissioner in the Commission of Inquiry into the financial activities of public bodies, enterprises, and offices as regards their dealings with former President Yahya A.J.J. Jammeh. You are further designated as the chairperson of the Commission. Kindly familiarize yourself with the Commission's terms of reference as a guide to your work. Congratulations and best wishes in your new appointment.
Now, our mandate as a committee is to look at the assets identified, sold, disposed of by the January Commission. While that is our primary mandate, it is essential for us to look at the manner in which the Commission itself was set up. To look at its administration, at least from a bird's eye view, not to go too deep into it. The question I have here is, in the third paragraph, there is reference to a terms of reference. Can you guide the committee as to which document is being referred to on the third paragraph, in the third paragraph?
Based on my reading of it, this must be referring to the legal notice that established the commission, because it's the legal notice that includes the terms of reference for the commission.
So when we speak of terms of reference, are we talking about the legal notice, or is there a separate document?
The legal notice includes the terms of reference of the commission.
Of the commission, right. Otherwise, we could call it the mandate of the commission.
Yes.
And that would be the terms of reference of the commission as a whole.
Yes.
Right, as a unit.
Yes.
Right. My qualm, or rather the committee's qualm, from the appointment is not in the manner in appointment, because you have stated the reasons why. But once appointed, the chairperson was not given a specific terms of reference from which to deduce the level of his authority, from which to deduce how he should operate within the commission. Would you like to comment on that?
Well, typically the Commission of Inquiry, which was established under Section 200, will be guided by the provisions of that section first and foremost, and then of course the provisions of the Commission of Inquiry Act, which contains supplemental provisions on how the commission should function, and in addition to that, the terms of reference, which is contained in the legal notice, provides the parameters within which the commission should operate as to how the commission effectively exercises how it functions effectively. That would be up to the commission to determine. In fact, it's part of granting the commission independence to determine its operational parameters.
Yes, I agree that as a whole, as a unit, it would guide them, and it would be better for the government to allow the commission rather to set the parameters as to how they would work. My question relates to the chair in particular, and whether he was given a terms of reference specific to him as chairperson of the commission.
Neither the chair nor the other commissioners were giving a specific terms of reference outside the legal notice or the Constitution or the Commission of Inquiry Act.
All right. In the instance of the chair, perhaps I can agree. And of course, the chair is the doyen of the bar. We would usually or normally perceive that he would be able to deduce the provisions of Section 200 and the Commission of Inquiry Act to figure out his role. However, as is the practice in public service, each servant is afforded a tailored TOR specific to them as to how and what they are expected to do to go about their work. And while there's no reference to a specific terms of reference in the chair's letter, I would invite you to look at MOJ 3A. The content is largely the same, But I would ask you to indulge me to read the third paragraph once more.
It's addressed to Abubacarr George, of course. Same date, 12th of July 2017. Appointment as Commissioner to Commission of Inquiry is the heading. And the third paragraph reads, kindly familiarize yourself with the Commission's terms of reference attached herewith and your attached TOR, meaning terms of reference, as a guide to your work.
So you agree with me that there was a specific TOR for the specific commissioners, at least for the commissioner that goes by the name Ms. Abubacarr George?
I wouldn't say there was a separate TOR. I would consider this as an error in the drafting of the letter. It makes reference to two TORs. The only one that exists is the one where it's contained in the legal notice.
Yes, but once more, I would contend and say that, in fact, this letter is drafted in standard public service format to entail a specific TOR, because every public servant needs to be guided on their specific function, their mandate. Now, while the TOR for the commission is the mandate of the commission, because the mandate of the commission would not actually be found in the law. The authority of the commission, rather, would be found in the law. The mandate of the commission will be found in the legal notice. And that is what I perceive as the TOR for the commission, which I would more appropriately use the word mandate, because it's more appropriate for an institution. The mandate of the institution was the legal notice. Now, the letter makes reference to a TOR for the specific commissioner. However, this letter, and the letter is copied to you, of course, from your head of admin. However, there is no document attached to it to spell out the functions and the role of the commissioner.
Yeah, and that's why I said I believe that third paragraph, the reference to a second TOR, is an error, and the only terms of reference, which you call a mandate, it's also a mandate, is what is contained in the legal notice. Now, as to how the commissioners function, that would be up to them to determine. I'm not sure if I get the crux of your question, but it's similar to a judge of the High Court. They are guided in their work by the rules of court and procedure, etc. In the case of the Commission of Inquiry into the Janneh Commission, we left it up to the commission to determine its own rules of procedure and evidence, as we did for the other commissions like the TRRC and the CRC.
Yes. Their rules of procedure, I would agree with you, it would be much more appropriate to allow them to develop that. It would show a mark of autonomy. However, the specific TOR does not relate to rules or how the commission operates. The TOR is meant to guide the servant, the public servant, in his or her daily function. Now, if from your testimony, I'm deducing that you did not see a TOR fit. You do not see it being a necessary addition.
Well, yes, there was no need for an additional TOR over and above what was contained in the legal notice.
Could you expound on that?
Well, what I mean is the legal notice is very clear as to what the commission is expected to establish as a matter of fact. Now, it was up to the commission to determine how best to achieve that. That would be my reading of the situation.
And the distinction between the role of the chairperson and the other commissioners, who would draw that? Would it be appropriate for the commission to draw that?
Well, why not? It's a three-person commission. I am assuming the reason why, not assuming, the reason why we had three was because we expect in general the commission to arrive at decisions by consensus. And if there is no consensus and it's put to a vote, that's why we have the odd number, so that it will be by majority.
Yes, my qualm again is not about decisions. It's just about guiding the individual on their day-to-day work.
But Council, maybe I'm not understanding your question, because that was left, it's up to the commissioners to decide how they wanted to do that.
Yes, but Mr. Tambedou rather.
I'm glad, Tambedou, yes.
Tambedou, yes. It's the government who established this commission. It is the government who gave it its authority, its mandate, what we are referring to as the TOR of the commission. Because this is the aim of the government. Cabinet sat down and conceived an idea and said, this is what we want. Don't you think it is prudent for Cabinet to go a step further, as alluded in their appointment letters, to provide a concise TOR? Now, I enjoy your examples, because you make the example of the judge, of a judge, and I will ride along your example and say, a judge of the High Court, when appointed, perhaps the Chief Justice would issue them their letters and say, I am sending you to the criminal division, I am sending you to the civil division, or I'm sending you to the commercial division. They know that they're going to sit over commercial cases, right? They know the general mandate of the judiciary, but they themselves have a terms of reference. It's important because the terms of reference keeps the public servant, it's a tool for accountability. You outline what roles the public servant is supposed to carry out, and that's the point of reference. Otherwise, we have no point of reference except for the mandate of the commission, which is a collective mandate. Now, perhaps you can help the committee deduce from the legal notice, which is MOJ 2, to figure out how the commissioners would go about deducing their individual responsibility. Please guide us. In the absence of their individual TORs.
Your reference to public servants is helpful, but does not necessarily apply mutatis mutandis to this scenario. The public servants are governed by general orders, etc. So there is a standard set of rules that apply to public servants. In the case of the commission, that has the powers of a high court judge in certain respects, particularly procedural matters. I think the commission, I am at a loss as to what you're driving at, because
let me put it this way.
The terms of reference are clear. They have a task at hand. They can determine their own rules of procedure and evidence in terms of what rules to apply, what rules not to apply.
That is not in dispute.
Yes, so I don't understand. What else are you looking for in terms of the functions of the commission?
Let me put it this way. We have it on good authority from our investigation team that in the case of other commissions, the roles of individuals were clearly spelled out in subsequent commissions.
In commissions in this country?
Yes.
Okay.
The roles of individuals were clearly spelled out.
And the roles of the commissioners themselves?
Yes.
Really? I would like to see that.
Well, it is authority. Just like your reports from different institutions, I would have to say that this report is also a verbal report. Unfortunately, you see so how difficult it is to...
No, but you're talking about written terms of reference.
Yes.
So I would like to see something like that.
All right. In the absence of the physical document, because it is not available for you now, what would be your comment if I were to put that to you, that in other commissions, the roles were clearly spelled out? The role of the commissioners, the lead
Spelled
counsel,
out by who?
by the government.
By the government. So you would agree with me then that in this case, compared to those commissions, we allowed more independence in this commission than in those ones, because we did not prescribe how they should function.
Well, I would disagree with you, because it is not, providing a TOR is not dictating how they function. It is outlining what is expected of them. Now, how they function to reach, to carry that out is up to them. I would agree with you.
We did.
And I would also agree with, I would also disagree that it gave them independence. I would say that it clouded, it muddied the lines. There were blurred lines as to who is to do what and who is responsible for what.
I don't think the commissioners or council or I sitting here will agree with it at all. I think the distinctions were very clear as to what was expected of council, whose role was to assist the commission, and the commissioners who presided over the hearings and proceedings of the commission. I think those roles are very, very clear.
You will stand by that submission then?
Absolutely.
Okay. Let's proceed to the last commissioner. That should be MOJ 3C. A similar provision is there, and that is Mr. Baimasen. He was also headhunted.
Yes.
Now, how did you come to be acquainted with Mr. Baimasen?
Oh, I knew Baimasen personally before he was made commissioner.
He was a friend.
Yes, you can call him a friend.
Yes, and you trusted in his professional abilities. That's why you headhunted him.
Absolutely.
Great. Let's move on to the secretary. Who is responsible to appoint the secretary?
In this case, it will be the president, based on the legal notice, I believe.
And the law? And
Yes.
the constitution as well?
I'm not sure if it's in the constitution, but perhaps the commission of inquiry.
Commission of inquiry.
Yes.
Okay. So the law and the legal notice are in tandem, that it is the president who appoints the secretary.
Yes.
Did you as well advise the president on the appointment of the first secretary, Mr. Alhaji Mahmoud Quran?
Certainly, I recommended his appointment to the president.
All right. Let's stick to Mr. Quran. Was a TOR provided for Mr. Quran?
Not to my recollection, but the idea was for the commission to provide Mr. Kurang with his terms of reference and his responsibilities.
Was this idea communicated to the commission?
It did not need to be communicated to a commission. The commissioners are in charge of their proceedings. They would be responsible for the different activities and functions of the different units, including council and her team, and of course the secretariat.
So if I'm understanding your testimony, the government set up a commission, gave it a mandate, and allowed for the commission to develop its own TOR. Now, I see a double standard in the submission, because in one breath, the submission is that the commissioners and anybody else can deduce their terms of reference from the collective mandate. On the other hand, the submission is that it is for the commission to develop the TOR. Now, which one is it?
I'm not sure there is a double standard there, Council. The terms of reference of the commission, which you call a mandate, the mandate of the commission, is included in the legal notice, and the responsibility, and the objectives are clearly spelled out. How best to achieve that objective will be up to the commission to determine. What we did was to provide a secretary who shall be under the authority of the commissioners, and of course council and her team who will assist the commissioners. And I think the delineations of those responsibilities are clear for the commission. It was for the commission to develop that further. What we did was to allow them the independence to do so in a manner that they thought was fit for them.
Okay. Now, Mr. Tambedou, I would want us to apply our mind here. This exercise is not only a fact-finding exercise, but the results from this exercise would advise future endeavors. Now, from your testimony, it seems you have great compassion for the country. And I would want to tap into that compassion and ask, if you were to redo it again, you did mention that you would stick with the same team. You were quite confident in the team. If you were to do it again, would you allow the lines to be blurred as they were, or would you define their roles?
Well, first, I think the first point of divergence is that I don't think there was any line that was blurred. As far as I'm concerned, we allowed the commission to, as I said, develop its own internal working protocols or guidelines, if you like. I'm not sure I can call them terms of reference, but perhaps they are protocols or guidelines that they could rely on, and we allowed them that independence because we didn't want to be prescriptive, if you like. And two, if I were to do some of these things again, I have said over and over and over, self-reflection is part of growth, and there's always room for improvement. There's always things that you could do differently at various points if you had different sets of circumstances. So my answer to you would be, if I had to do things again, certainly I would have learned lessons from how we did it in the past and improve upon any new process we were going to put in place.
Okay, we will come back to that shortly. Back to Alhaji Mamadi Quran. It was your recommendation, of course.
Absolutely.
Another individual that you are well acquainted with.
Another individual that I knew.
Okay.
I wouldn't call him a friend, but I knew him.
All right. And how did you come to know Mr. Quran?
I've known Mr. Quran for a long time. He was my head boy at St. Augustine's High School.
I see. To the best of your knowledge, had Mr. Quran ever worked in the public service prior to his appointment as a secretary?
I don't know, or I can't recall, but our focus in getting Mr. Quran was to identify someone in the private sector who had knowledge in accounting background, etc., whose skills we thought the commission, such a financial commission inquiry could make use of. So we identified him, and I recommended him on that basis.
In what capacity was he supposed to exemplify his accounting skills?
That would be under the guidance of the commission. It will be for the commission. We just provided the tools for the commission to make use of. And the tools here is someone who has a background in accounting, in finance, etc. And Alaji fitted that bill for us.
I agree with you. He has an excellent background in accounting.
You wouldn't be head boy in St. Augustine's in my days if you weren't bright.
I want to agree with you, but again, it's another thing that perhaps will escape me because I wasn't there those days. But I would want to ask whether you were aware that Mr. Quran had the skills of a secretary or the expertise of a secretary.
I am hesitating to answer your question because what would constitute the skills of a secretary?
You see, I like that question because it tempts me to go back to a TOR, because the TOR would clearly spell what would entail and what would be the skills of a secretary.
Yeah, but you see, that's you're focusing only on written TOR. In this case, the secretary would be under the guidance of the commissioners, particularly the chair, and his role would be to execute the directives or orders or instructions or requests of the commissioners. And
however, don't you think secretaries also have an advisory role? It's not just to take instructions.
in this case, no. My idea of a secretary in a commission is equal to perhaps the registrar in court. The registrar in court is there to execute the orders or instructions of the court to ensure that the court's orders are complied with, and to carry out other administrative assignments that the court may from time to time order. Registrars don't have any advisory roles for the court, as far as I know. And so I would describe the role of a secretary to a commission of inquiry in that manner as well.
So you don't agree that a secretary has an advisory capacity to their work?
In a commission of inquiry?
Yes.
No.
Okay. I would again contend with you. I do believe that the secretary always has that prerogative, at least to advise. And
if you equate that to the role of the registrar in a high court, would you say the registrar in a high court has an advisory role?
in fact, I would equate it to the role of the judicial secretary. That would be a more appropriate comparison. Or the role of the clerk of the National Assembly.
No, Council, it's different. The role of the judicial secretary is constitutional, and in fact, it was an invention after the 1997 Constitution was adopted. Before that, there was no judicial secretary, if you like. But in any event, we have differences of opinion in terms of the role of a secretary. In my view, it's more akin to the role of a registrar in court and not the judicial secretary at all. The judicial secretary has additional responsibilities that the registrars in court do not have. And to impute that the secretary to a commission of inquiry shares those same responsibilities is to, I believe, broaden the scope of a mandate of a secretary to the commission.
So then what was the need of his accounting background if he is not to advise on any accounting? He is just to take instructions.
Well, it would be up to the commissioners to make use of that background if they see fit. They could consult the secretary if they saw fit, but to arrogate to the secretary the if you like mandate to advise, then that's another thing. You are empowering the secretary to provide advice, and I believe that is not the point of the commission. His background certainly would be relevant if the commissioners wanted to rely on it. It's a tool again at their disposal. Because once you give the secretary more powers, then you're almost putting him almost at par with the commissioners, and that wouldn't be the role of the secretary.
Again, I would contend with that. I would not think that giving him advisory powers or any similar such powers would equate him to the commissioners. He does not make decisions. He simply puts forward his proposals to the commissioners for their consideration.
I don't think even without those powers he was stopped. He could be stopped from doing that. He could always offer his views to the commission.
Precisely.
There was nothing that I think would stop him from doing that. But once you formalize that into an advisory role, then you give it a little bit more weight, and that's the fear that I am that I am concerned about.
Yes, but you just stated that it was inherent anyway for him to offer a word or two
If
at the discretion of the commissioners, of course. It's not sacrosanct, they have to take it. Yeah, okay. So the other component I was trying to highlight was that Mr. Alhaji Mamadi Kurang, from our records, to the best of our records, never served in the public service. This is a public body. It operates much like any other public institution. Of course, it has its own unique attributes. However, you did mention earlier today that the trend in commissions of inquiry, in this country especially, is to heavily tap from the public service. And I believe that is just logic, because it is the public servants who are au fait with the modus operandi of public offices. And they know what obtains. Now here's a person who is emanated from the private sector. And I'm not saying that's an anomaly or a bad thing, but my qualm is that Mr. Kurang had not exhibited any such skills as a secretary. In fact, I would want to think that his best position would have been an investigator of some sort, since the subject matter of the commission was matters of finance. And I'm not in any way trying to insinuate that your appointment was wrong. I'm just trying to understand the rationale. He's a finance expert, no secretarial experience, but yet he becomes the secretary to the commission. And I would think that if there was one position that would be reserved for a public servant, at least to bring some sort of institutional benchmarking from the public service, it would have been the secretary. I'm just thinking out loud.
That's why we brought in counsel and Bensouda.
And counsel was in private practice. Of course, I'm aware that counsel has served in the position you were serving and has served in various other positions in the public service, but counsel was in private practice.
You know, the choice of counsel Ami Bensouda was also deliberate. And it was based on all of the reasons that you just gave now for a secretary. She was in private practice. She still is. She has a very...
I would just stop you there, Mr. Tambedou. I promise you we will get to Miss Bensouda next.
Okay.
Let's finish with the secretary.
But for now, the idea was to bring in counsel who ticked all the boxes that you have identified for a secretary. In this case, the role of a secretary, as I said, was to carry out the instructions of the commission, and for the commission to rely on their expertise if necessary.
Can you just clarify that last bit? I had missed that. My apologies.
No problem. The role of the commission in this case, as I said, was to carry out the instructions or orders of the commission, to head the secretariat, the administration, and to make themselves and their expertise and experience available to the commissioners if they needed it at any time.
The last bit sounded like an advisory role to me.
But I did say that
are we saying that it's...
I did say that there's nothing stopping the secretary from offering his advice, and there's nothing stopping the commissioners from accepting that advice, in spite of the absence of any specific written terms of reference for them.
Okay. Let's move on to lead counsel. How was lead counsel selected?
I identified her and approached her.
You mentioned some debates.
Debates as in...
You had mentioned previously some debates before I interrupted.
Yes, no, I was saying the profile of lead counsel, why I approached her. So in addition to the criteria that I had mentioned earlier for the identification and appointment of Mr. SBS Jane, Councillor Ami Bensouda also had all of those qualities. But in addition to that, she was a very experienced public servant. She held the position of Solicitor General for a number of years, acted, of course, as Attorney General for some time, and then went into private practice, where she continued to represent public enterprises, and then had a very, I believe, successful commercial law practice. So she fitted all the additional requirements that I wanted for counsel to the commission, and that's why I approached her.
All right. Just the same question again. Were you an acquaintance of Miss Bensouda?
Professionally, yes.
So you had known each other professionally?
It's a small country. We all, there were a few lawyers in those days.
Yes.
Unlike these days, we have a lot more.
Indeed. We have arrived.
It's a good thing.
Yes, it is. Indeed. I want to look through the criteria used, the lenses used to appoint lead counsel a bit more closely. And with the utmost respect to Ms. Bensouda, who I have the utmost regard for, was the criteria of conflicts of interest looked at by the ministry?
Right from the start, absolutely.
And that was consistent for all?
Absolutely, for
personnel.
all of them. The one question that I always ask is there any reason why you cannot perform this role? That's always.
And was that question posed to lead counsel?
Oh, absolutely, yep.
And what was the response?
Her response was, no, there was not, but if it ever occurred, then there was a mechanism to deal with that. There is always, you see, maybe I should elaborate further on this issue of conflict. I think there is a lot of misunderstanding about conflict. Conflict of interest depends on the individual circumstances of each case. And just because there is conflict or conflict is foreseeable doesn't mean the people affected should automatically not be given a responsibility. What occurs is when, and that's why mechanisms to manage conflicts of interest are included in a lot of arrangements. And what typically occurs is that once you realize that you may be conflicted in a certain situation, you request or you are recused from that situation, and somebody else comes in and deal with the situation and take you out of that equation. So just because there was potential for conflict doesn't mean that you will not assign someone work. If we go by that principle, nobody will be given any work in this country. This is a country of 2 million people. I mean, the professional class is so little that we all have had dealings with one another in some form. We all have personal or family relationships in a place like this. So if we go by the notion that once potential for conflict arises, the person should not be given an assignment, then I don't think anybody in this country will ever be given any assignment at all. Who knows? I may actually be related to you. Who knows? It's a small country.
I think we actually might be related. I will start calling you uncle from now on. Yes, but I do appreciate that. It is a tiny country. And perhaps that should have been a reason to keep it public. Because it's a tiny country, you don't give it to somebody that's in private practice, but you give it to somebody who is in public practice as the practice obtains.
Again, we're going to the issue of independence. We wanted total independence in this commission, to the extent that we avoided going to get people serving in public offices, because we wanted a process that was completely detached from government. Completely detached from government. And that is why we went to seek people from the private sector.
But we have established that I would save that for a bit later. I would take your answer for now. So the question was posed rather to Ms. Bensouda, whether there could be any possibility of conflict. And the response was in the negative, but with a disclaimer that where it arises, there is cause for disclosure and perhaps subsequent recusal.
And that did occur in the course of the Jani Commission hearing.
That's fine. We will get to that.
Okay.
However, I would like to show you a document. Honorable Chair, I am making reference to the submission by the Honorable Secretary General submission, and it's folio 151 in the submission. I would ask that the Secretariat provide the witness with folio 151. The document I'm looking for, folio 151, is a document that is stapled together. It's a series of documents stapled together, rather. You would see that I'm looking at page 5, the second document, which is the 5th page. If the Secretariat wishes, they could borrow my copy, and I could allow the witness to peruse it for a minute and retrieve it back.